We are now moving to the first plenary session, which I have the honor to chair. The first plenary session is titled Adapting Private Law to New Technologies. We have very distinguished speakers who will each speak for 20 minutes. And for the speakers, please don't overrun. I have clear, very strict instructions to interfere if when the time is up and speakers continue to speak, because as Norman has mentioned, the conference program is really packed. Apologies in advance if I have to intervene. After those three speakers, we have 20 minutes at the end for Q&A. Again, please use the chat function to send your questions in so that we can present them to the speakers or to one particular speaker, whatever you have. Our first speaker is Professor Christian Twigg-Flesner. Professor Twigg-Flesner is Professor of International Commercial Law at the University of Warwick. His research and teaching interests are in the areas of commercial, consumer, and contract law, with a particular focus on the implications of digitalization. Professor Twigg-Flesner has widely published, and of course, many of us are familiar with his work, so it's great to meet you today in person, although only online. Professor Twigg-Flesner will speak today about the importance of a methodological framework for private law and new technologies. Professor Twigg-Flesner, thank you for joining. The floor is yours.
Thank you very much, and a very good morning, good afternoon, good evening to everybody in the room. And I just want to start very briefly with a thank you to Norman and Eliza for inviting me to speak at this conference and for accepting my rather ambitiously titled proposal, the content of which may perhaps be slightly more mundane, but we shall see. And thank you to Professor Watt for the very kind introduction. Allow me to share my screen so I can speak to the slides I have prepared. I hope you can see them now. So my attempt this morning is to, well, I claim to present a methodological framework, but perhaps a simpler way of putting it is to say I'm going to give you a thought process that might be useful when you are trying to think about how new technologies impact a particular field of law, a particular area of law. The conference has the rather ambitious title or opening title, Adaptation or Transformation. But I would like to recalibrate this ever so slightly to then seek into my presentation, because I think the question is really one between when adaptation would suffice, bearing in mind that adaptation is really just an action. We are tweaking the law. We're making subtle adjustments to the law to make it work in light of new technologies, or a transformation of law that could happen as an outcome when we have tweaked so much that law has ceased to be recognizable if we look at it before the technology came along and caused us to make changes. And with this in mind, I would like to now really run through the kind of thought process, the methodology that I think should be followed every time when we think about the implications of a new technology for whichever area of law we're interested in, although our focus this morning, of course, is particularly on private law. And I think it is really important because a lot of you will have read a lot of outputs, publications, books, listened to a lot of conference presentations. And ever so often, I think some of you might have wondered, well, does this actually make sense? Are we actually talking about something that's real? Or have people got a little bit carried away by the promises made by those who have developed the technology without really thinking about the overall context? And I want us to just try and pause, take a deep breath, and approach the whole question of how technological developments impact the law in a slightly more cautious manner. I'm not saying technology doesn't have a big impact on certain areas of law. That is not what I'm claiming, but I'm suggesting that perhaps we shouldn't get too rapidly carried away without having explored this properly. And I'm as guilty as the next person with having sometimes been carried away by the hype. So I'm not at all claiming some position of superiority in this regard. The obvious starting point when we are looking at new technological implications, and this is where I think quite often things fall down a little bit, is to understand the technology itself. provocative rather than defending a particular view. But what is important is that we think about what new technology actually involves. What is going on with this technology? What does it really do? What is really new about this technology? Is it just a development that looks exciting, but is really just a gradual development, a sustaining technology in Clayton Christensen's terminology, or is it something really quite radical? And an obvious danger is that the terminology used, for example, in the technology sector may mean something quite different to, say, lawyers or social scientists or politicians or whoever. And we've all seen this clash of terminologies with our very famous phrase, smart contracts, where as lawyers, we think they're one thing, and technologists think it's something else. And we've all heard about Buterin's apology for using the term in the context of blockchain, when he didn't really think there was a connection between legal contracts and smart contracts in the technological sense. So we need to be mindful of how terminology is used in different disciplines and how we might misunderstand one another. And I know there's a lot of work being done to actually address this issue now by having a taxonomy of terminological terms at various levels, and that's going to be a really important development. Secondly, of course, new technology comes with a lot of hype and sweeping claims. Blockchain is probably the prime example, and there's a wonderful piece by Professor Schillig in the Modern Law Review earlier this year about the hype curve, how the technological hype curve has also been reflected in the academic hype curve, where there was a lot of excited output about blockchain technology and smart contracts and the benefits and the excitement it brings, followed by the inevitable downwards turn in the hype curve, where people are saying, actually, we've not really quite got this yet. And I know Eliza has in particular written some interesting pieces that have calmed the waters a little bit. So I'm sure Elizabeth will have something else to say about this. But the technology itself isn't necessarily what our main focus should be on anyway, because technology is a tool in a sense, and it is used as a way of developing new applications of technology. So blockchain isn't the technology itself we should be interested in, it's the application of that technology that really matters. What can you do with it, and what is realistic? And those are the kinds of things we need to understand a bit better. And this brings me to my next point. The context for the application of the technology also needs to be understood, because again, if we just look at technology, we might assume a lot can be done with it, but perhaps that's misunderstanding what the technology is doing. So rather than thinking about the technology and trying to devise law for the technology, think about the uses of that technology. How is the technology going to be used in a particular context? For example, when we talk about protocols on the blockchain, which can be used, of course, to support the automation of contractual performance and so on, what we are really talking about is not smart contracts and blockchains and all the baggage that brings with it, but rather we are talking about the application of a particular technology to facilitate automation. And whether that is AI and algorithmic contracting or blockchain-based contracting is really secondary. What matters is what is the impact of automating elements of contractual performance, contract conclusion, and so on. So clarity needs to be gained as to the kinds of applications for which the technology could be used, but also which of these applications are likely to be used in practice. Would commercial parties really adopt this technology? Do they really want to automate everything, for instance? Would consumers be happy to surrender everything to technology? Or would they like to perhaps retain a greater degree of control than is sometimes assumed? Those are all questions that need to be considered. After this stage, I think it's important to look at the issues that technology raises in the context of particular applications. So rather than asking, is AI good or bad, or is blockchain a problem or not, look at how the technology could be used, how the technology is adapted, and identify here what the likely issues might be that these particular technology applications could create. And this is important because, for example, if I stick with the smart contract scenario, it is going to be extremely rare for users of smart contract technology, if they wanted to go down that road, to really start messing around on the blockchain directly and writing protocols themselves. This will all go through intermediate applications. There will be blockchain smart contract applications that use the technology, but provide an interface that allows lawyers or even business people to effectively create transactions without getting bogged down in the detail of the technology. So therefore, the focus needs to be on the issues that the application, the context creates. What does the process of contract automation really raise in terms of novel challenges, if at all? And if there are novel challenges, it's the solutions that need to be required to address those issues we need to really focus on, rather than whether it's a bad thing that blockchain as a technology, for example, is pseudonymous or makes it more difficult to identify a contracting party. Those are asking, to my mind, perhaps not quite the right questions, because the technology is the basis for developing applications, and that's where it really matters. Once we have got to the stage where we have identified what the issues of concern to us are, particularly from a private law perspective, for example, from a contract law perspective, from a tort law perspective, at that point, we might then come up with some solutions, some possible ways forward, some answers to the questions we have identified. And then the question has to be, well, what does current law actually say in this regard? How far does current law go? And here, I suggest that there are two ways of going about this, one helpful way and one less helpful way. This is perhaps slightly more controversial. When we look at the existing law, my suggestion is that the useful work that we can do is not simply to map the law in its entirety onto the technology. Some of you may be familiar with the English Law Commission's advice on smart legal contracts, a very detailed, lengthy document where they have done just that. They've mapped the entirety of English contract law onto smart technology without really thinking about where the difficult issues are going to be. It was very much a mechanical, quite pedestrian mapping onto technology. And I don't think that's been particularly helpful. Had they instead said, okay, well, what is actually going on when we start to use this technology? What is actually happening to contracting itself? And therefore, what are the kinds of questions that might arise? Had they done this, it might have been perhaps a much more valuable exercise. The outcome might not have been massively different. It might still have concluded that contract law, the common law of contract in this case, is sufficiently robust, but it would have given us a much clearer, more focused analysis. So the key question should be, when we are looking at how law relates to the issues we've identified as creating these new questions, is whether existing law is clear, already provides clear answers, is perhaps some interpretation of existing rules or principles required. For example, can we take quite open-ended, open-textured norms in a very flexible way to allow us to accommodate the issues raised by new technology? In the consumer field, for instance, and I'm sure we'll hear more about this later, the European Unfair Commercial Practices regime is turning out to be incredibly flexible and adaptable to the use of new digital technologies. And therefore, that's a good example of how through some guidance and interpretation, we can actually go quite far with our existing legal regimes. But even if we think existing law is doing quite well, there's still a subsidiary question, because it might still leave the legal position insufficiently certain. We can say, okay, we think this will work, but until the law has been clarified, perhaps by an appropriate ruling by a court that can establish precedents, there might be uncertainty for the users of the technology, for business, for consumers, and so on. So we need to be also asking not just whether law works, and it might work to us as academics, but also whether how the law works right now provides a sufficient level of certainty, of legal certainty, to allow commercial parties to plan forward, plan ahead, to manage risks, to be reassured that the transactions they conduct using this new technology are going to be effective and are going to be endorsed and upheld by a court if it came to this. And even if we are confident that existing law can cope, we might still ask whether it's doing the best job, because existing laws might already be open to criticism for a variety of reasons. Dare I mention only the consideration doctrine that's persevering very strongly still in English contract law and is causing so many headaches for contract variation even to this day. So once we've done all this, we might decide that all we need to do is a relatively minor step in terms of adaptation. We might have to make perhaps minor adjustments to the law to clarify some ambiguities. We can maybe solve this through issuing some guidance, as has already happened in the example of the Unfair Commercial Practices Directive. Sometimes we just have to tweak the law ever so slightly to make sure that any small ambiguities are resolved, but we're not really talking about significantly rewriting the law or making great substantive changes. Here, the approach summed up by the label functional equivalence is often deployed. CCTL has been very much leading on this by basically saying there's nothing greatly to worry about electronic developments, digital developments. We just deploy some functional equivalence rules and away we go. This is happening, for example, at the moment in the context of electronic trade documents. We have the model law from CCTL. We also have a bill currently going through the British Parliament doing the same thing in a slightly different way. But when we look more closely at what's been happening here, it seems to me that the functional equivalence pursuit is actually introducing quite a different system. So sometimes functional equivalence isn't necessarily the answer, but it's often deployed to try and find an initial connection between the digital world and existing rules designed in a physical world. And finally, of course, we might have to rely on judicial interpretation to provide the necessary development of the law. This is sometimes suggested by the Law Commission to try and advance the law. We don't need to adopt legislation, but we need to provide some clear guidance to courts who can follow our guidance when they are faced with an appropriate case. Alternatively, rather than just adjusting the law, we might have to come up with design requirements. Some issues do not require new legal rules or new legal rights, but they might require a rule set or guidance given to those designing applications that take advantage of new technology, and to get them to ensure that they do what is necessary, that the kinds of steps already envisaged in existing law are followed, and that perhaps there are certain features built into these applications that allow for the technology to work within existing legal regimes. Again, I'm thinking of consumer law, where there are already quite many detailed rules, as I'm sure we'll hear about later. And sometimes the key is not to worry about the technology undermining those regimes, but rather the fact that the technology could be harnessed and ensure that it basically builds on those regimes in designing applications that will make life perhaps easier for consumers or indeed for commercial parties. So if there is a danger that the development of new technological applications would collide with existing legal rules or the application of the new technology, perhaps it can be managed not by issuing detailed new legal rules, but simply by providing design requirements. Again, already something that is happening, for example, in specifying how you can create a sufficiently reliable system for electronic trade documents. However, it might get to the point where we realize that existing law and design requirements won't get us very far, and we might have to sit down and think about new rules, possibly new doctrines, new concepts. Digital content and software has been a perennial issue, and much has been written about this, and changes have been made increasingly to address specifically the supply of digital content, of software, and so on. We are looking at now at the impact of digital assets and how digital assets can slot into existing personal property law regimes. And there are discussions on the way, for instance, that would suggest some adaptation of the law, some development of new doctrines is required. But when we are talking about new rules, doctrines, or concepts, there are still different ways we can go. We can develop rules by analogy, or we can be more radical and really think about tailored rules which are not necessarily trying to develop existing law into a wider terrain, but which are wiping the slate clean and are completely recalibrating existing fields of law. Analogous rules seek to maintain coherence with existing laws. We have seen this in the context of digital content in the UK and in Europe, for instance, where the rules on conformity of digital content with the contract very closely mirror those developed in the context of goods. But this isn't always appropriate. And sometimes we really have to sit down and think more carefully about how we best address the issues that the application of a new technology has raised. And here we might be less concerned with the impact on existing areas of law, because sometimes it is necessary to just be creative and develop something new. And if those rules are specifically geared towards the issues this new technology creates, then we are really looking at an additional body of rules that doesn't necessarily undermine the coherence of existing law. And Brownson talks about this in terms of coherentism and regulatory instrumentalism. Now, when we get to this stage, tailored rules departing from existing patterns, at that point, I think we are reaching the possibility of true transformation, because then we are looking at developing tailored rules, creating new transformed areas of law. These can eventually, if the new rules are sufficiently clear and perhaps better suited to the context, can really become utilized as a new basis for completely recalibrating an area of law. And this could, of course, have a really transformative effect. We move away, for example, from a contract law that's based on two parties negotiating face-to-face and thrashing out every single term, to a contract law that's primarily focused on standardized contracting through automating technologies. Perhaps that's the way it might go. It might not. I know I'm out of time, so I better stop here. I've gone through a lot of ideas very quickly, and I'm sure there'll be plenty of questions and scope for discussions, but I hope it's opened up the discussion for this conference. Thank you very much for listening.
Great, thank you very much, in particular for keeping within the time frame. That was a fascinating outline how we should approach these issues, starting from the common terminological and conceptual framework all the way to designing, if necessary, a new system. Thank you very much. And as you said, I'm sure there will be many questions. Next, we are very happy to welcome a really old Hong Kong hand, Professor Andre Jansen from Radboud University in the Netherlands. Great to see you, Andre. Professor Jansen specializes in contract law and tort law, European private law and international sales law, and artificial intelligence law. He is the chief editor of the European Review of Private Law and editorial member of the International Arbitration Law Review. Today, Professor Jansen will discuss about performance by AI, and he will challenge the notion, actually he will ask whether this will challenge the notion of contract law. Over to you, Andre.
Thank you very much for a kind introduction. Thank you very much for the invite. It's a pleasure to present here today. And also thanks to the organizers that you make me present at 8 o'clock in the morning, so I can do other stuff later. I'm very sorry, I don't feel great. I got a cold, so I hope my voice will suffice for 20 minutes. But I hope that will be all right. So I won't use PowerPoint, as otherwise you can hardly see me. So you have to concentrate on me. And so I am PowerPoint. So we hear a lot about AI and law, but mainly in the field of regulatory work. You know, what you already mentioned, the AI Act or tort law. And we will hear a lot about tort law later on. And however, I would like to shed some light on a lesser discussed, but I believe also very important area, namely AI and contract law, and more specifically on contract performance by AI. So my today's talk has the title Performance by AI, the End of Contract Law as We Know It. But honestly, isn't the title a little bit sensational and maybe overly dramatic? Because personally, I read a lot in the past, basically with all new arrival of new technical development, and this is also what Christian said, that there is the end of contract law as we know it, the end of tort law, etc., you name it. So is performance by AI really the end of contract law as we know it? And spoiler alert, I believe it depends. So to start with two scenarios. Scenario A, there is no AI involved for contract performance. So the scenario is as follows. The debtor uses a reliable employee for performing a contract. Nonetheless, the employee causes negligently a damage to the creditor. The creditor claims damages. Scenario B, this time an AI is involved, which means the debtor is the debtor is not using an employee, but an AI, for example, an AI-driven cargo drone, to perform the contract. He uses the AI completely according to the instructions of the producer many times before without any problems. However, this time the AI causes a damage to the creditor due to a bug which appears after a mandatory update of the AI. Also here, the creditor claims damages. First question is, does it make a difference whether the debtor is using an employee or an AI to perform the contract in the outlined scenarios? Second question, and if it makes a difference, do we agree with that result, or is it indeed the end of contract law as we know it? So the focus of my talk is on damages for breach of contract as arguably the most important remedy. Furthermore, my focus is on English common law on the one hand and on civil law in the form of German law on the other hand, knowing that there are many differences in the common law world and in the civil law world. Why the mention folky? Well, because the different requirements for damages for breach of contract in common law and civil law are sort of comparative law classic, as we will hopefully see later. Well, doing that in just 20 minutes is very demanding, so please apologize upfront for all my shameless super simplifications I'm doing here. And whoever is interested in an in-depth analysis of the entire problem, please let me know, as there is a comprehensive written form of today's talk in the Cambridge Handbook of AI. Let us start with the common law perspective. Yeah, so let us start with contract performance by AI and damages for breach of contract under common law. As probably most of you know, the common law follows in principle here a strict liability approach, which means any breach suffices to award damages, so regardless of the fault of the debtor. But Murray said, well, to avoid a crushing burden for the debtor, the remoteness test was developed more than 150 years ago in the very famous case Hadley and Baxendale, which is basically a test of foreseeability to limit the liability for a breach of contract to a reasonable extent. And here, if you read the remoteness test properly, so the loss must be foreseeable not only as being possible, but the parties must have considered it as a probable consequence of a breach of contract. But to repeat, the remoteness test only focuses on the foreseeability of the loss, not on the foreseeability of the cause of the loss. And this means for our scenarios, well, it does not matter whether the loss was caused by the employee, scenario A, or by the AI, scenario B, as only this foreseeability of the loss is decisive. So the remoteness test under common law is therefore not AI sensitive, which means that for common law of contract, the rise of AI is more or less, I believe, business as usual, and does not constitute a serious challenge for common law. Let us now move quickly to the civil law. Yeah, let us move to the civil law perspective on contract performance by malfunctioning AI, using, again, the German legal system to illustrate possible problems and challenges for civil law systems in general. First of all, like the English law, also the German law foresees a similar but not identical remoteness test to limit liability to a foreseeable extent. Well, in the interest of time, I will not further elaborate on the German remoteness test, but I can let you know that regularly the German remoteness test will, like under English law, not be a serious hurdle for damages resulting from malfunctioning AI. So let us better move on quickly to the real hurdle for damages for breach of contract under civil law, namely the fact that in opposite to common law systems, the civil law systems foresee a fault liability regime. And possibly the best quote for summarizing this civil law position is probably a quote from the famous German jurist Rudolf von Jhering in his book Das Schuldmoment im römischen Privatrecht, in which he writes, "It is not the loss that obliges compensation, but fault." And this has been the position of the German Civil Code from 1900 to its present form. And so Section 280 of the German Civil Code foresees a fault liability of the debtor who is in breach of a duty arising from an obligation. All right, so fault liability. And like in many other civil law systems, the debtor can be held liable for A, his own culpable breach of duty, or B, for a culpable breach of a duty by others. So we'll now discuss whether the debtor using a malfunctioning AI to perform a contract can actually be held liable for the losses caused either by his own culpable breach of duty of care or by a third party's culpable breach of duty of care. So let us start with the liability of the debtor for his own culpable breach of duty of care when using a malfunctioning AI for contract performance. Well, what is fault at all? Most of the legal system have quite a similar understanding of the notion of fault, according to Section 278 of the German Civil Code. So the debtor is at fault if he acts with intent or negligence, and a person acts negligently if he fails to exercise reasonable care. Failure to exercise reasonable care. And the question is now, could just the use of AI for contract performance already amount to a negligent behavior of the debtor? No. There is a large consensus here that only the use of AI for contract performance as such is not already a culpable breach of duty of care, which means more is needed for the assumption of a culpable breach of duty of care by the debtor. And there is an agreement that the debtor using an AI for contract performance is at fault and therefore liable if A, the AI is not suitable to fulfill the designated task, so wrong AI, if the debtor does not follow the instructions from the AI developer, or last but not least, if the necessary updates are not made. However, there is one very crucial question, and that is whether the debtor has the duty of care of constantly monitoring the AI he is using. And personally, I don't believe so, and I'm not alone with this. Also, Christiane Wenderhorst, former director of the European Law Institute, think the same. But why? Because with the increasing autonomy of the AI, the monitoring obligation shifts from the debtor to the developer of the AI, as he has, in fact, the actual control over the AI. So he is mainly in charge of monitoring the AI. The debtor using the AI has only very limited or maybe even no possibility to monitor its functionality, and the law cannot impose a duty of care on a party which he cannot fulfill. And therefore, it is very likely that in our scenario B, use of AI, the debtor can prove that he personally was not at fault under German law, as he fulfilled all his duties of care. So he followed all instructions, the AI was up to date, and the law does not impose further duties of care on him, such as constantly monitoring the AI. Okay, but what about the liability of the debtor for a third party's culpable breach of duty of care? In our scenario B, that would be the AI. Because as in many other legal systems, for example, Switzerland, Austria, or the Netherlands, also in Germany, the debtor is not only liable for his own culpable breach of duty of care, but according to section 278 of the German Civil Code, he's also liable for culpable breaches by persons who he uses to perform his obligation, so contractual assistance. The rationale of these provisions is relatively easy to understand. Debtors should not be able to avoid liability just because he uses a contractual assistant to perform his obligations instead of fulfilling the obligation himself. And I guess you can already spot the problem with that provisions, section 278 of the German Civil Code and similar provisions in other civil law codes. They require that the contractual assistant is a natural or legal person, and this is exactly not the case with AI at present. And despite all discussions about the topic, AI does not have legal personhood. So section 278 of the German Civil Code cannot apply to AI, which means that their actions cannot be attributed to the debtor using AI for contract performance. And this has the effect that in our scenario B, the debtor could probably avoid liability while he could be held liable for his employee's culpable breach of duty of care in the first scenario. And that is, I believe, a pretty remarkable difference. So in short, the legal situation in Germany right now differs fundamentally from the common law, as it makes a great difference under current German law, whether an AI or the debtor himself or his contractual assistant perform the contract, as the debtor can, status quo 2023, probably escape liability using AI for contract performance. So after this wild ride through the world of contract law, let me slowly come to an end and having an outlook. So my initial question was whether the performance by AI is the end of contract law as we know it. According to me, as I said at the beginning, I believe it depends. So the common law is not forced to a major paradigm shift, I believe. Its basic idea, the strict liability for damages for breach of contract, which is limited by the remoteness test, also works when the AI is used to perform a contract, as the liability remains centered on the debtor. So to some extent, the common law concept here is not AI sensitive, and it functions regardless of who is performing the contract, the debtor himself, his contractual assistants, or an AI. So for damages for a breach of contract under common law, the rise of AI is not the end of contract law as we know it, but is more business as usual, as I said before. For civil law, at least in the form of the German law, and probably also for some other civil law systems, the situation is very different. The rise of AI for contract performance could shake the fundamentals of civil law, and in particular, one of its pillars, namely the fault requirement for damages for breach of contract, one of the signature features of civil law systems. So we have seen that the use of AI for contract performance could lead to complete discharge of the debtor from liability. And this has mainly two reasons. The first reason is that a large part of duty of care, especially the duty of care to monitor the AI, will move from the debtor to the developer of the AI, and the debtor can much easier avoid liability, arguing that he personally hasn't culpably breached any duty of care. The second reason is that the provision which attributes culpable breach of duty of care of contractual assistance to the debtor fails to apply, as it is only applicable to natural or legal persons, but not to AI. So if AI is increasingly used for contract performance, it could indeed lead to the end of contract law as we know it, as the debtor might regularly escape liability. And especially the comparison of current German law, in principle, no liability of the debtor, with the common law, with a strict liability of the debtor, is quite striking. So if the German legislator decide to make contract law AI ready, he must answer fundamental questions. The first question is whether we need and want to grant AI legal personage to make the attribution of its actions to the debtor work, or are there maybe other better solutions like AI assistant without a legal personage? The second question is whether we want a strict liability of the debtor for AI he is using for contract performance, even if that is not in line with civil law thinking. And if the legislator wants to adhere to the concept of fault liability, the final question is how to make this deeply human concept work for AI. Comparing the actions emanating from the AI to a human culpability standard, or should we right away develop a novel AI culpability standard? So to sum up, I believe that the civil law, at least in the form of the German law, is at a crossroad, and that the rise of AI will to some extent mark the end of contract law as we know it. If the legislator refrains from changing the law, there is a danger that the debtor of the future will be completely discharged from liability for damages caused, as he's using increasingly AI for contract performance. If, however, the legislator decides to make contract law AI ready, he needs to decide very fundamental questions. And some of the questions have, hopefully seen, the potential to fundamentally change the contract law of civil law as we know it. Thank you very much for your attention. I'm looking forward to the discussion.
Thank you very much. And in particular for this fascinating comparative analysis, also showing that many of those rather detailed questions of contract law cannot be decided without dealing with very fundamental issues, such as the personality issue that you have mentioned. I'm sure there will be lots of questions later, but let's move on to the last speaker in this first plenary session, my colleague, Professor Elisa Mick. Elisa teaches legal technologies, e-commerce, contract law here at CHK Law. Her research interests focus on the legal aspects of transaction automation. Elisa is a member of the UNCITRAL Expert Group for the Digital Economy, a member of the Inclusive, which I think Professor Christian Twigg-Flessner has criticized earlier. We'll get back to that point later. A member of the Inclusive Global Legal Innovation Platform on ODR here in Hong Kong, a research associate at the Tilburg Institute for Law, Society and Technology, and an affiliate researcher with the Center of AI and Digital Ethics at the University of Melbourne. Professor Mick's topic today is testing the limits of contract law from AI to blockchains. Elisa, please.
Hello, everyone. Dear Lutz, thank you for the lovely introduction, and thank everyone for coming. I have put on my glasses to kind of tune in with everyone else and to look more intellectual. Otherwise, everybody will be distracted by me being blonde. Okay, let me share my screen when I find it. There we go. Okay, testing the limits of contract law. And of course, I had to add a bit of hype. Hope everybody can see it. From AI to blockchains and back. So of course, my job is much easier because I had Chris and Andre speaking before me, so I can kind of pick up. Please trust me, I have not seen or read their papers or presentations before. So I will basically I've been looking at those questions forever. How far can the principles of contract law be stretched to accommodate technological change? And Christian was talking about adaptation and transformation in line with the topic of this conference. I'm just going to be far less elegant. I'm just going to talk about stretching. It's not even adaptation. It's much, much simpler. But my question is always, which technologies are relevant in the first place? Just because we have some technology, whether it's AI or blockchain, it may not mean that any stretching, adaptation, or even transformation are necessary. And please note that while Andre was talking about contract performance, I will focus on something that's one step earlier. So I will focus on contract formation. So, and Andre is performance, I'm formation. Okay, now let us look at this lovely email that I have sent to Norman this morning. Let's just kick off with an example. Hello, Normal. By the way, this is not my actual email address, so don't get tempted. I would like to purchase 1,000 of your Tesla shares for the price of US 100 per share. If that's cool, just say yes, Elisa, and assume it is sent from my email address and by myself. Now, my question to you is, okay, I can see Norman's face. He's not very happy. I think I'm giving you a good price, so please smile. Okay, let's ask some simple questions. How did I arrive at the price in this offer? Because I just offered 180 US dollars per share. I might have calculated this price in my head because I'm actually quite brilliant with mathematics. Of course, I'm not. I might have used the calculator. I might have asked my broker. I might have asked my boss. Or maybe I have used trading software that, predicts all sorts of commercial trends. Well, can you tell? Look at this email again. Can you tell how I calculated the 180 US? No, you can't. Also, assuming it's number 4 and I use trading software, can you tell what type of trading software it was? Was it something that relied on classic symbolic AI? Or was it trading software that relies on the novel machine learning approach? I'm afraid you can't. Objectively speaking, when you look at a statement, such as an email message or a website or a WhatsApp message, it may be impossible to determine whether this statement was made by a human, made by a computer, it was computer generated. I think this is particularly relevant here with ChatGPT, or, and to me this is probably the most important bit, it was made with the assistance of a computer. You really can't tell. And now please look at, and many of you will not agree with this, but I am reducing AI to automation. I actually very, very rarely use the word AI, and I focus on automation instead. So when we look at human history, we can see that humans have been using technology to perform physical tasks. And this has been the case for thousands of years, okay? But the focus was always on physical tasks, whether it is, for hunting, for making fire, for building houses. And progressively, we go from, shovels to cranes, and, the technology becomes more sophisticated. Gradually, over the last, say, 200 years, we have also started to automate, which means use technology to perform cognitive tasks, such as calculation. So how does AI sit with automation? AI is deployed when the task to be automated involves the processing of large amounts of information. And the type of AI, because again, I use the word AI very broadly, but depending on the task, depending on the sensitivity of the information and the timeframes involved, you would be using different types of technology or different types of computer programs, different types of AI. So what in a cognitive setting, when, for example, I choose which shares to buy, or when I choose the price, what can you automate? You can automate the acquisition and analysis of information. You can also automate decision recommendation and selection. So in the first step, the AI collects information and analyzes it. In the second step, it gives you recommendations between different actions. Sometimes one level up, it actually selects the optimal action. And the last bit is called decision implementation. So it actually does the thing. So you set your algorithm, for trading for a particular type of share. You set a limit order or a market order. And frankly speaking, you don't sit on the screen. You don't sit by the computer. You go and play golf, or you go and give a lecture in contract law. Please note that increasingly in the last couple of years, we bypass the second step. So the AI, the system, the software, acquires, analyzes information, and then implements the programmed action. Because the red bit actually requires humans in the loop and some sort of human choice. So why do we automate contracting or trading? As I said, and this sounds a little bit simplistic, but this is actually the case. When you have a lot of information coming in, so it's a question of scale, you have a lot of data, for example, market data, and very little time. Because, for example, in the case of if you trade on the stock market, you should be making decisions within minutes or seconds. Of course, no human can do it. So here, the poor guy in his baby blue suit, he's still kind of trying to remember what was the price for the particular order, what was the size. He forgot because he lost his sticky note. In the meantime, the beautiful red robot already placed 63 orders. So it's a question of time and amount of information to be processed simultaneously. Okay. Now, what if we actually automate the process of contract formation? Those of you who are already a little bit bored, I can give you the executive summary that right now in 2022, we don't have a single case where a judge has questioned the validity of a contract made with a vending machine or on a website. There isn't a single case. So technically, we could pause the whole presentation here. Contract formation can be automated. Goodbye, everyone, and we can have a longer break. But of course, not so fast. So please look on the left. I'm always reusing this slide because this is my absolutely favorite slide on the planet. This is the first vending machine. According to historical records, this was invented in 2015 BC. So this stuff is over 2,000 years old. This was a temple in Alexandria. This is an analog vending machine dispensing holy water. And on top, you put a little coin, lowers the lever, the water comes up. But this is a vending machine, accepts coins for holy water. And on the right-hand side, we have an IoT, fully automated vending machine that technically fulfills at least some definitions of AI, because to an extent it is autonomous. It only requires humans for restocking and in the case of malfunction. And of course, we have multiple cases on contracts conducted with the help or with the assistance or by means of vending machines. Not a single one has been held to be invalid. Courts actually completely gloss over the fact that the contract was formed automatically. Now, my question to you is, do you think on this continuum of technological progress, there comes a moment where suddenly the contract with the vending machine becomes invalid or at least doctrinally suspect? I hope you would agree with me. It would be extremely difficult to actually pinpoint this moment in time when such doctrinal revolution resulting in invalidity would actually take place. Of course, here we have the biggest vending machine, also known as Amazon. Technically, it is a vending machine. You select, you pay, it comes out. Sorry, I'm kind of being, again, maybe a bit simplistic, but now that we have digital products and digital context, the performance can occur within minutes from formation. Please note that technically, again, Amazon fulfills every requirement or every qualification to be an AI, because Amazon, what we see here is just a very simple, lovely, user-friendly interface, but Amazon sits on a very, very deep vertical stack of technologies that include every possible AI breakthrough. So including blockchains and including very, very sophisticated machine learning algorithms. Yet in 2023, we don't have a single case that would be questioning the validity of contracts with Amazon. And I trust each of us has bought from Amazon at some stage in their life. And I think you were pretty confident buying from them, not with them, from them. Yes. Okay. We also, of course, have algorithmic trading and high frequency trading. And please note that a study in 2019 has established that around 92% of Forex was automated. So every day we have literally, I don't even know how many, but billions of transactions that are billions of contracts that are actually formed and Andre also performed by means of automated systems or AI. Oh my God, that can't be true. I know what many of you are thinking because I'm always trying to think about what my students are asking in class. Oh my God, that can't be true. Contracts, after all, require intention. Contracts require mental states. Contracts are built on agreements and, of course, the famous meeting of minds. And the weird thing is, and this goes back to the theme of this conference about, transforming, adapting, or I, just like I say it, stretching. Contract law is extremely, I'm talking about, common law of contract, apologies. So I don't know much about German law. Actually, I know nothing about German law. So in common law jurisdictions, contracts have, strictly speaking, nothing to do with the actual intent of the parties. A contract is an obligation attached by the mere force of law to certain acts of the parties, usually words. So those are really, really far-reaching statements by the biggest names in contract law. So normally there's a lot of, for the last couple of years, and it revives with every AI summer, we had quite a few controversies surrounding the validity of contracts formed with the assistance of computer programs. Please note, I am avoiding the word by computer programs because the computer programs have no legal personhood. So it's always with the assistance of computer programs. And those controversies or doubts always derive from a misunderstanding of the role of mental states in contract law. So common argument, computers cannot have mental states, they cannot have intention, therefore computers formed by means of computers cannot be valid. I fully agree that computers cannot have mental states. That has actually been established from a technical perspective. The thing is, consensus ad idem and actual intention are abstractions. They are not requirements. It's something we read in Contract Law 1 in the textbook, but it's actually not required. The common law of contract relies on something called objective theory of contract, which basically only and exclusively relies on objective appearances of agreement. So if the parties seem to engage in agreement, the law will infer the requisite intention. But, this still sounds a little bit sterile. So how does it actually map on AI? The weird thing is, when you read the relevant cases, and again, I'm sticking to what I know, which is the common law of contract, normally we all focus on the party making the statement, but the common law of contract actually focuses on the mind of the addressee of the statement. So the addressee of the statement is in practice more important than the maker of the statement. And this is, common law is very, very pragmatic. It's not very idealistic. It focuses on maintaining a market economy. And in mass market transactions, outward appearances or objectivity are really everything because it's impractical, if not impossible, to examine every email, every statement you get You can't look at it and think, oh my God, was this really Norman who said this? Was this Elisa? Or did Norman use an AI? Or was it maybe not Norman at all, or somebody pretending to be Norman? Okay, so contract law in common law of contract, very pragmatic. And most importantly, and this is why, from a contract formation perspective, contract law really stretches because it focuses on the output, the statement itself. It never, ever inquires why or how a statement came into being. So there is no inquiry as to the technology used to generate or assist in generating a statement, and it only matters what the reasonable addressee of such statement was entitled to conclude. In other words, the focus is on the output of the decision-making process, not on the decision-making process. So please note, as I said earlier, we use computers in different contexts, and we use them to a different extent to automate various aspects of our daily contracts. Sometimes we literally let them contract by themselves. We just give the prior instructions and then we walk away and play golf. And please note also that today, not a single between Amazon, I'm using Amazon in general, I'm talking about any big e-commerce website. Now, none of those contracts has been held invalid due to the absence of direct human involvement. On Amazon side, same thing, supermarkets with self-service terminals, which are increasingly popular in Hong Kong. So I'm actually not stealing from the supermarket, from any of the local supermarkets. I walk out after paying, although I never interacted with a human being. So for those of you who still don't fully believe it, this is my latest paper, fully peer-reviewed, and please, it's like, I don't know, 500 footnotes, and you have all the cases and all the references. Now, I think I have 1 minute left. What about blockchains? Well, this is going to be a big disappointment. Absolutely nothing. Because I couldn't, I can see some disappointed faces already. Sorry, guys, but this was an intentional letdown because I really wanted to make a point. Of course, smart contracts, if you really look underneath the, if you really look inside and examine what a smart contract is, smart contracts can automate certain aspects of performance if such performance involves the transfer of cryptocurrencies or crypto tokens. But otherwise, I agree with Christian totally. Blockchains are databases, and it doesn't matter what type of database you use to, for example, save your contract in. So apologies for the disappointment with one sentence about blockchains, and I look forward to your questions. Thank you.
Thank you very much, Elisa, for this. Right through contract law from the perspective of new technologies, and I'm sure there will be good questions. So for everybody now, if you have any questions for the speaker, the Q&A session is open. Please chat your questions in, and so that I can read them out to the speakers. Let me start with the questions are coming in. Let me start with the first question, originally for Christian, but probably for everybody else as well. You have nicely outlined the steps that need to be taken for to adapt to, in terms of legal developments, to the new technologies. The question is this process, is this adaptation different from adaptation to other developments, climate change, financial crisis, and? Are there specifics related to technology? Yeah.
Thank you. Not necessarily. I think some of these thought processes can be adapted to other new phenomena and the challenges they pose. In fact, I was debating at the end of my presentation. I didn't get to it because I thought it would just add another 10 minutes that I didn't have. But often in the context of transformation, we also throw in the phrase disruption to law. And I think disruption is a heavily overused phrase. I'm guilty of it myself. I've used it. But what I try to do in my writing is to try and give it some meaning, to reinstill some meaning. And I think legal disruption, in whichever context, only arises when we get to the very end of a transformative change in the law. That's when we have real legal disruption. I wrote about this idea in the context of the impact of COVID time regulations on contract law. There's a big book published by in Europe, Coronavirus and the Law in Europe, and I've got a chapter in there on legal disruption where I kind of explain the thought pattern behind it. And that's similar to the thought pattern I described in my talk today. So it can be deployed to deal with other challenges where they have a potential impact, say on contract law, on tort law, on property law. It's kind of just trying to make sure things are worked through gradually and people don't see something and leap ahead and make big conclusions based on misunderstandings of what the real issues are. Thank you very much. Andre, anything to add?
Yeah, maybe to top up on what Christian said, I agree with what Christian said, and maybe it's always striking, Christian. You were always very critical with smart contracts and so on, and I agree. But this is something very often. It seems to me as if it's a sort of hype to some extent, and then suddenly a lot of people, so what I read so much, and this was also part of my introduction, that everybody said, okay, this is the end of contract law, this is the end of tort law, this is the end, and I also dislike very much the term disruptive technology. I couldn't agree more. So I'm always very careful whether we need eventually really change the law, or so I'm quite careful. Okay, maybe at the very end it might be, but and I think there is not a crucial difference between AI or what the other examples Christian mentioned. Thank you.
Thank you very much. Before I ask Elisa, I need to confess that I have written 5 years ago an article titled "The End of Comparative Law as a Result of AI." Elisa.
Yes, and of course it's very catchy, and I've done it myself. So, but the conclusion is normally, no, it's not.
Elisa.
Just a quick one. I always say to my students or in conferences, technology is a question of fact, and we need to understand facts. And the frustrating bit is, especially amongst regulators, some academics are also guilty, they start making proposals or building theories, especially in the EU, they like really specialize in it, without actually understanding the facts. And this is the same thing, going back to the original question, whether it's climate change or COVID, get the facts and then think what's next.
Thank you very much. Let me read out a question again, a new question for all speakers. It seems that all speakers agree in their basic approach that we should first look at adaptation or stretching and not call for transformation of the law too quickly when discussing new technologies. I would be interested to hear whether there is anything that they don't agree on. The three of you. Right.
Well, thank God we're not in the same room. Oh my God, no. I'm not going to say anything.
This is not inquiry. This is not, sorry, but it would require me to inquire into Elisa's and Andre's state of mind, and I don't think I have the cranial maps to do that.
All right, I won't tell you from whom the question came. Of course,
we disagree on plenty of things, but we also are scholars who discuss a lot, who are able to amend our views. We're not necessarily sticking to our guns. We acknowledge that we've maybe ourselves jumped the gun in the past and made broad claims and carried away by the hype. But I think we've seen the light of day, which is encourage others to just pause and think in the same way.
I think we should also bear in mind, we were only, Andre and myself, we were only talking about contract law. When you go to, so it is very, very narrow. And Andre, I love the word you used. It's not AI sensitive. I'm gonna steal this. # royalties. But when you go to consumer protection, oh my God, I don't know where to start. We need so many adjustments. I wouldn't even use transformations, but so many adjustments. No? Okay, Christian says no. Okay, I'm just not going to say anything.
I'm just disagreeing. So the questioner has something that we disagree on. I'm shaking my head deliberately.
Great. Can I be the peacemaker and move on to the next question? For Andre, you said that AI does not cause serious challenges for contract performance in common law systems. But what if AI completely takes over, is completely automatized? If contract performance is completely automatized, which means there would not be any breach of contract any longer, not possible, far away, 100 years, in which case, I believe that part of contract law would disappear. I know, Elisa, you disagree because it's not possible, but it's a thought experiment.
Okay. Yeah. Yeah. Well, I'm always, I cannot think of a case where that could be possible, but maybe I'm too narrow-minded. But I think there is no. It's like that. So even if it's, even if it's fully automated, if there is a strict liability, it's a breach. So I can't see. Maybe Christian or Elisa, maybe you have a different stance, or
No, again, sorry, we agree. But if you automate something, and there's very rich literature, it is a human decision to automate something, and it's also a human decision to choose the technology and the degree of automation. So you have three separate decisions. The first step, automate in the first place. B, degree of automation. 3, technology. So why should I escape liability for my bad choices? Of course, if something happens, if there's a malfunction, if it was wrongly used the program, and there is damage, I would be, if I'm just the person deploying the AI, but I haven't created it, I would be suing the person I bought it from. But otherwise, automated contract formation and performance, it's being done, 1 million times per minute.
Right, but
already.
Doesn't that mean that if it's automated, the idea of automation means that there is no variation? That means you would perform, you must perform. There is an automatic performance, and therefore there is no breach. There can't be a breach as a matter of idea.
No, that's not in English contract law.
No. Well, this is where I come back to.
It doesn't matter how you perform, because it doesn't matter how you perform. It's your decision whether you perform yourself or whether you delegate.
Sure, but the problem is that if there's an automation, you wouldn't have any deviation from what was agreed previously because it's automated, and then you can't have a breach.
I don't see it.
That depends on how you automate.
Exactly.
Assuming that automation is a singular concept, that automation is either everything's automated and you can't control it, or it's not automated. But nobody in their right mind as a commercial party would give in to that degree of automation, even if once upon a time in the future it becomes technological possible. How many commercial parties would take the risk of letting things completely run away? And of course, this thought experiment is based on assumptions. There's a lot of talk, of course, about AI, singularity, conscience, and all this kind of stuff. Even today, even ChatGPT and all the hype around that, we are talking about a pretty decent data processing system that's pretty impressive in its outputs, but it's got no idea what it's saying. It's so far away from anything clever or intentional or anything else. So as long as the technology is not getting anywhere, and if you listen to experts in AI, they're pretty hesitant about this idea of where it might go in the future and how quickly. So the idea of automation itself to that level, A, as a possibility, and B, as something that commercial parties and the consumers would willingly surrender to, seems to me to be so far-fetched that it's just not going to happen. Now, it might be a Luddite in this sense,
no, you're right.
Get away. But I just don't see it. I just don't see that kind of level of automation without any built-in control, without any built-in fail-safes, without any built-in emergency brakes ever to happen. I just don't see it.
Well, I do see it, and we'll talk about it later. But I was talking about that level of automation, actually. We have another question, and I think we still have time. We now have algorithms that write codes, for example, website pages, but it is foreseeable that algorithms can write other codes that run certain operations down the line, who is liable for any consequences? Do we trace it back to the original author? That goes to probably Elisa first.
Could you repeat the last bit?
Sure.
Sorry
down
for this.
the line, who is liable for any consequences if the algorithm is written? Algorithms can write other codes if AI writes. That's the question, basically. If
it is very
problem with the code, and that is.
This is a very great question, but I mean it's actually quite easy to answer. I assume the person asking a question talks about OpenAI's Copilot. It doesn't matter how you write the code. You can write it yourself, or you can take libraries from GitHub, or you can automatically generate it. If you don't do testing, and maybe I would just actually do some formal verification in the beginning. If you don't test it, if you release it in the wild, you're liable. It's your problem.
So
it doesn't matter how you write
it. The one who's liable.
Yeah, I mean the person deploying it.
Okay.
Yeah.
Thank you. Any other questions? Please chat them in. We have 5 minutes left.
But maybe with the last question, Andre, you could elaborate, because I kind of hijacked this one. So with coding, if you write software, who's liable if you use Copilot?
Yeah, well, I think I don't know whether that's so. I guess that's more a topic of the later panels, right? At least as to my understanding, if it is with the new product liability directive, and if I'm not mistaken, right? So, or am I misunderstanding the question?
I mean,
so,
when you use code that was generated by was generated automatically by Copilot, for example, but you choose to deploy the code in a live environment.
That's the question, I think. So it's the originator.
How's that different? How's that different from me manufacturing something using a machine made by a third party? Where's the difference there? If I'm a car manufacturer and I've had a machine supplied by Siemens to help me make car parts, how is that different from a digital machine that's written some code for me that I then deploy? Genuine question. To me, I don't see the difference.
Yeah,
you are releasing it to the public in the end. If you release the code, I mean, if Apple, this is why even Apple or Microsoft, they have all those weekly or monthly updates with patches, because something goes constantly wrong. There is no perfect software. So we already face this. And frankly speaking, as a consumer, I absolutely, this is going to sound very harsh, I don't care why it's not working or why is it working, just fix it.
But also, if I'm using a code thing, if I use a code thing to write code for me, and there goes something seriously wrong with that process, I've got a separate contract with that company that's given me the coding thing. So OpenAI, for instance, and I can sue them quite happily for all the losses I've suffered.
Oh, they exclude liability. They put this little thing on the bottom. Yeah, don't use it for it. Don't use it in any live environment before extensive testing.
We got one more question. Can we move on to? Sorry, can we move on to the last question, because we are running out of time? This question comes from Professor Amrit Subhadasi from the School of Law, KIIT, becoming soon a university in India. The question is, in an era where robot lawyers are used for arguments, what is their feasibility in automated commercial contracts? I think, Elisa, that goes to you. What is robot lawyers?
I don't know of any robot lawyer in existence.
Yeah, well, I also have to be very. I did a lot with robo judges and robo lawyers. So I'm very, very careful. So I'm not aware of right now of a robo judge or a robo lawyer which is fully functioning. And for very often you see these images on the cover. Elisa and Kristen, I guess you've seen it very much. So you see a robot wearing a gown and flocking the hammer. And you see that also, this is a very big misunderstanding of what AI could do as being a robo lawyer or a robo judge. So I personally, I'm very careful.
Thank you very much. And I think this concludes the first plenary session of our conference. Many thanks to the speakers. Many thanks to everybody for joining, and in particular those who have sent in questions. It was a very informative starting point for the discussions that we have in the next sessions. We now have a break until 3:20 Hong Kong time. So that's a break of 10 minutes, and we will see all of you back at this place. Thank you again.
Thank you very much, everybody.